Yellow, and of course, thank you for tuning in. This is for those who can do more. You have options in the description below. Pick the one that fits you best. I always suggest the membership program. Why? It's cheap. Simple as that. But understand that by you. You watching from start to finish, clicking the like button, subscribing, and all that good mess pushes the algorithm forward and really helps my channel. So do not minimize the essence of who you are. Thank you. Let's get started. I did that in 30 seconds. I'm getting better and better and better at this. Anyway, hi. Bushy eyebrows, sir, is in trouble. They want to kill him. They want to legally kill him. Death penalty. Yes! Excuse me? Yes. Now listen to me very carefully. We all have an opinion, but in the eyes of the court, you're innocent until proven guilty. But, allegedly he's guilty. In my eyes, 100%. However, the defense has a right to dispute, and they are disputing. What are they disputing? The DNA. Listen, it's going to get juicier, and better. But first, for those who are new here, I am Eddie Stehanzekio, and this is just my point of view. What is going on?
They didn't have to come here.
This morning, in an NBC News exclusive, the father of victim Kaylee Goncalves reacting to news that prosecutors plan to seek the death penalty against Bryan Kohberger, the man accused of murdering his daughter and 3 other students at the University of Idaho.
Sense of relief. I'm glad that we're in a situation of strength, and the evidence is there, and we feel that we can, they can go forward with this.
The family's attorney believes it's a clear-cut death penalty case.
If you're not going to pursue the guy for a death penalty on a case like this, who are you going to pursue for a death penalty?
In just a few hours, Kohberger is set to return to a Moscow, Idaho courtroom for another pretrial hearing. His legal team is requesting records from last month's grand jury indictment of their client and are asking the judge to pause legal proceedings until they receive those materials. Already a key part of the case for both sides, Kohberger's DNA and where it was and wasn't found. While prosecutors said in a court filing earlier this month that Kohberger's DNA is a statistical match to DNA found on a knife sheath at the scene of the murders, his lawyers say authorities did not find any victim DNA in his apartment, office, home, or vehicle.
Is this your car?
He's had over a month before those search warrants were executed after the crime to throw away his clothes, wash his car, clean out his apartment. There's multiple ways to explain the lack of DNA in his vehicle, in his apartment. There's not a lot of ways to explain his DNA on the sheath of the murder weapon.
The legal battle is also unfolding just over a mile from the scene of the quadruple homicides. The off-campus home where Madison Mogen, Kaylee Goncalves, Xana Kernodle, and Ethan Chapin were killed was set to be demolished. Before a judge ruled it should be preserved. Now the University of Idaho says they hope to have the house down ahead of the new school year. The Goncalves family says the house should be preserved through trial.
I don't want to sit 6 months from now and hear somebody in the court case say, well, I really wish we could be in the house right now.
Very good point. I think the house should not be demolished because it is part of the evidence. And even if it's not, leave it alone. Okay, my grown-up brain tells me property taxes. That's a rental, and the landlord cannot rent the place. Nobody's going to rent it. What are we going to do with property taxes? What's going to happen? So I don't know if he gets, the landlord gets commissioned or gets compensated in the back end. These are important stuff, that you have to think about. But no, in terms of this trial and the case, no, the house should not be demolished. Now, them seeking the death penalty, I think is amazing because that lawyer makes a very great point, is that if you don't seek the death penalty for this case, then what's the point of even having, what's the point? Great match. And also kudos to the parents. I don't know. I don't know how you heal from having a child ripped away from this world. I'm telling you, and I've told you this before, when my mother passes away, because nobody's eternal, she will. As much of our differences happen, I'll be discombobulated, whatever the word is, and I would need like a good 5 years to recover, maybe not 5. I would need a moment. I can't imagine if I lose a child. I don't think I'll be speaking to anybody. I don't think, no, forget it. Forget it. Like, forget it. How do you function? How the hell do you function? That pain is beyond me. Now, the most important part of this segment is what one of the I don't know if it was the prosecutor or the journalist said. You can explain the lack of DNA anywhere else. You can explain it. He had a month. He could have cleaned it up. Okay. But how do you explain the statistical match on the murder weapon when you say you don't know this woman, I don't talk to this woman, I've never been around this woman? How do you explain that? I think this is something I've told you guys 1,000 and 1,000,000 times. He could do cartwheels. He could beat the fairy for all I care. Fairy, with your wand, why is there blood on your star? Do you know what I'm saying? That's what I'm trying to say. Nobody wants to die. Nobody wants to die. Not even narcissistic, sociopathic murderers. They don't want to die. Please, death penalty will wake them up. Let's see what he says. So right off the bat, they come in with a smile. Listen to me. Listen to me. Listen to me. If you're my defense lawyer, I don't know we're not smiling. For something this severe, I need you to be a grunge, a grudge, a grudge, a grudge, whatever the name is. Nobody's smiling. This is not fun, and there's a death penalty off the top of my head. No.
All rise. Thank you very much. Please be seated. Good afternoon, everybody. Okay, let's get on the record, please.
I can't help but notice how calm and poised he is for something so severe. Like, you want to kill me? You could kill me. No, like I told you before, if I was in court, all my lawyers, I don't want to see you smile. We're all gonna be unhappy together. What? No, it's not funny. It's not funny. It's not funny at all. And I don't care what you could talk to me about today that's gonna make it funny. It's not funny at all. But pompous, arrogant. It's not. Listen, not for nothing. I'm not asking him to make himself so small. But what I'm asking him is at least. For the sake of the body language, at least, right? Make yourself small. Make yourself small because make yourself small. Even try to lie to us. No, he's too cocky.
Okay, we're on the record. This is State of Idaho versus Brian Kohberger. Case number CR 29222805. Mr. Kohberger is in the court. He is represented by Ms. Taylor, Mr. Lobston, and Ms. Massett. The state is represented by Mr. Thompson and Ms. Jennings, also Mr. Nye and Ms. Beatty.
Yeah. Pretty poised. We're going to fast forward this to something a little more interesting because courts can get pretty boring when they go through the formality. On the record, this is Monday, Tuesday, Wednesday, 6 a.m., sunny sky. Have a seat, left and right, up and down, diagonal. You know, they can get pretty boring. Let me show you this picture. Really quickly. Okay. So, first of all, look at that bailiff staring Kohberger in the face. How uncomfortable is that? Look, I'm already being on trial for, they want to kill me already. And you're sitting there staring at me like, how do I, hi. Like, I don't, Daddy bailiff. That's ridiculous. So he has to sit there and stare at the defendant? Okay. Look at that. Okay. There's something about courtrooms that is so sterile. Like, nothing about the court makes you want to have fun. Why are you all smiling? No, everything about this court in general makes you want to get out of here. Get out. Anyway, that was just a funny, stupid stuff. Okay, let's continue.
I think we've sort of boiled things down to some issues on a motion to compel discovery. Some of those issues have been resolved, some have not. So let me go to you, Ms. Taylor, to start off. Where do we start?
Your Honor, we would request that we start on the defendant's motion to compel and second motion to compel. I believe the third motion to compel will be heard on a different date.
True.
As it relates to the two motions to compel, and I'll present my arguments whenever the court's ready, but I can direct the court exactly to the numbers in those motions to compel that are still up for discussion today and request approval from the court.
Excellent. I'm ready.
On the original motion to compel, we are only seeking the court to order number 6 be complied with in that motion, in that particular motion.
Okay, let me take a look at that. Number 6. And so this is the motion to compel discovery that was filed on May 4th.
Yes, Your Honor, that's correct.
Number 6. And that is request number 160.
That is for request number 160, and that was in the second supplemental discovery request.
Okay, thank you. All right. And we're getting, is that me? Okay.
I love when the phone vibrated. The prosecutor's like, duh. By the way, that prosecutor beard is so good. My God. I think I later established that I do have a hair fetish. Not in a sexual way, in an admirational kind of way. Yeah, it seems like I'm obsessed with hair as of late. Whatever. We all have quirks. What's your quirk? Okay? At least I like hair. That's it. Not poop. I can't. Anyway.
Number 6.
Number 6 on that one, yes. On the second motion to compel, Your Honor, we are needing the court to order on request number 1, number 4, number 5, and I think that we have a plan for the other numbers, so those would be the 3 we need the court to order on.
Thank you. Let me make sure I'm looking at the same page. Okay, number 1 is request 1. Number 4 is request 23.
I'm sorry, Your Honor, it's number 2, request 4.
Okay, I apologize. Number 2, request 4. Okay. And you said number 5.
And number 5, which is request 109.
Thank you. All right. That's the second motion to compel discovery.
Correct.
All right. Do you want to make an argument about those?
I would love to.
Okay, go ahead.
Thank you. Your Honor, first, I want to start with talking about the discovery process. As the court knows, we have been representing Mr. Koberger since the very end of December of 2022. And during the course of the last several months, there has been a lot of discovery that's been requested and a lot that's been supplied. I come here asking the court to compel discovery. I'm seeking an order directing that we receive this discovery. I'm not seeking any other kind of sanction. I don't come here saying that the prosecutor has done something wrong. I come here saying that there are things that we have a disagreement about whether I should get them or when I should get them, and we seek a court order to assist us in this regard. Yesterday, we filed an exhibit that related to our motions to compel, and the purpose of that exhibit was to show the court how the discovery is coming in and what we are weeding through to try to find the information, and to let the court know that our office is making extraordinary efforts. Mr. Koberger's team works nonstop, and when we ask for discovery, it's because we have reason to believe it exists. So I wanted the Court of Counsel to be aware it's not a fishing expedition. These are real items that are really necessary to investigate this case and prepare Mr. Koberger's defense. So with that as the background and the frequent communication with the prosecutor's office to try to obtain the materials we need, we have come to an impasse in a few areas, and that's what brings us to court today. As the court knows, discovery is governed by statute 1309 and Idaho Criminal Rule 16. And the purpose of discovery is really to prevent an unfair trial, to prevent trial by surprise, and also to protect a charged person's rights to meet their defense. It protects their Sixth Amendment rights to have a sufficient and a prepared counsel, I should say, as we have a duty to investigate the case. So in preparing our case for Mr. Kohberger, we've asked for several things that we still need. I'll talk first about request number 6 in the first motion to compel, and that stems from discovery request 160. It's training records. These are training records of 3 specific police officers. Your Honor, we have not asked for training records for every officer that has had anything to do with the case. I would not want to stand here and let the court think that this is an exhaustive list of the officers that we might need training records for. But these are 3 officers that we've requested them for, and the state has indicated they're not willing to give us their training records. These 3 officers are officers that have each conducted critical interviews with critical witnesses in the case, made decisions about the interviews, made decisions about evidence, and conducted other kinds of investigations. We seek their training records to understand their processes. The training records, Your Honor, they are records that we've been able to obtain from various police agencies in the past. In this circumstance, are not records that I can find on my own. These are not things that are on the internet. They're not going to just hand them over to me. The 2 of the officers that we've requested.
Interesting. So she's complaining. Number 1, first complaint is she wants training records of the officers. Okay, look, we have. I know you can hear. Now, the stuff that sticks to my head the most is that she is harped on that. She is not letting go of that training record. And my sixth sense tells me if she is laser focused on that, it means that she suspects something. And my sixth sense also tells me it's something so simple. Just send the training records. Why wouldn't the prosecution not just send the training records? Why would the prosecution allow it to get to the front of the judge for the potential of the judge to compel it if there was not something potentially there that could help the defense? So then I asked myself the question, prosecution, what's the deal? Now, on the same flip side, if I'm the prosecutor, I don't have to do anything you tell me, lady over there, right? If I don't have to. So even if I could, I'm not giving it to you. That's extra work. And I'm not being paid by you to do that extra work. So my brain is churning, right? I'm paying attention pretty much. Oh, lawyers. Let me tell you something. They must go at the end of this, have a good drink and be like, oh my God, Judge Darrow, that was so crazy. Like, no, they don't do that, but I so would. Lawyers in the community of lawyering. Okay, let's continue.
Moving on then to our second motion to compel. And what we are looking for is a lot of information from the FBI CAST team as well as the FBI forensic examiner team. What we're talking about here is the CAST team are the FBI examiners that use cell phone records to provide a lot of information that found its way into the probable cause affidavit that the state relied on in arresting Mr. Kohberger. I had the opportunity to meet with the prosecutor, and they indicate that we will be getting those items in number 1 and number 6 disclosed to us, but we don't know when. So I'm asking this court to issue an order with a date certain to obtain those records. These are bits of investigation that the FBI conducted that relate to Mr. Koberger's cell phone, and the state relied on that in their affidavit to say that Mr. Koberger was in certain places at certain times. So these are bits of information and analysis that's been done since December. We are now at the end of June. We do not have those records yet, Your Honor. They are something that's been relied upon by the state for the PC affidavit to arrest Mr. Koberger, as well as to obtain a variety of search warrants. It's information that the state has agreed we should have, so we ask the court for an order with a deadline to get that. I want the court to know I don't think that Mr. Thompson or Ms. Jennings are trying to withhold this. I think they'll give it to me when they have it, but I think an order from the court saying this is the date certain may help them get the information a little bit more rapidly.
Interesting. So she's pretty much saying that she doesn't trust the FBI's investigation, or she wants to get a better understanding as to why the prosecution has relied so much on the report from the FBI in regards to the cell towers and his location. Why? I'm not quite understanding what she's asking here. That doesn't make sense to me at all. It's almost like she's just throwing somewhere at straws and throwing straws at the wall and expecting for one thing to stick. Eddie, what are you asking? FBI conducted a report. We got the report. That's what he made to the probable cause, right? The report involving the cell tower, where he's already, his location and stuff. I mean, these prosecution, they've been in the game for quite a while now. Okay, I see now. Okay, so her argument is that I want to see how you got the cell tower to say that my client's phone was there as opposed to there. But I think they say already that cell tower gives you a grosso modo idea. It gives you an area, right? It doesn't exactly pinpoint the location. But when you put one and one together, the reason why the probable cause was, the reason why that made it to the probable cause, because he has no business being around near that house. What are you doing there, sir? Right? You combine that with the knife sheath. Yeah, that's probable cause enough, lady. I don't understand what she's asking. Quite frankly, she's confusing me. Good hair, though. Yeah, let's continue.
I'll move on to our last request, and that's number 2 in the second motion to compel, request number 4. And that has to do with the FBI forensic examiner that told the state to look for a white Hyundai Elantra. This is the examiner that originally there were certain years looked for, and that year range was expanded. I believe I have the communications between the police department and the FBI about how that date range changed, but what I don't have is the report from the examiner. I did receive the CD, curriculum vitae, about the examiner late yesterday from the prosecutor's office, so I'm asking the court to order a deadline for the report to be given to the defense. Again, the court's read the probable cause affidavit that led to Mr. Koberger's arrest, and the court can see that this vehicle identification was heavily relied on by the state to arrest Mr. Koberger, as well as to obtain a lot of other search warrants. This is information that is very necessary for us to prepare our case. I don't think Mr. Thompson and Ms. Jennings are withholding anything. I think they don't have it, but I think we need a court order with a deadline so that we can get that. As the court is aware, the state has a duty to provide discovery to the defense. As the court is aware that not producing discovery, especially when it's material, can be a due process violation. And as the court is aware, the state has filed its notice of intent to seek death against Mr. Koberger. These are critical, relevant materials, all of them, including the police training records. They're necessary for us to prepare and present our defense of Mr. Koberger. They're necessary for us to do our investigation. They're necessary for us to prepare our case and our motion practice moving forward. These are things that we need to have. There is a heightened standard now that the state has filed its notice of intent to seek death, and these are very relevant, critical bits of information. They are discoverable, and we're asking the court to order that they be supplied to us.
Mr.
Well then, 1 second. Dog is barking. Let me just see who's there to murder me. I'm kidding.
So, Ms. Taylor's correct. She has everything that the state has in our possession. And we have worked diligently and consistently in getting her all the information that we have in a quick fashion. To date, we have discovered approximately about 13,000 pages of reports, 13,000 photographs, over 10,000 tips, and over 51 terabytes of audio and video information. So we are down to just a few points of disagreement.
Sorry, am I a little closer?
Oh, is it okay if I say?
Yes, yeah, that's fine.
Thank you.
Thank you.
First, with regard to item number 6 on the defendant's first motion to compel discovery, this involves training records of a couple of officers. Again, these are officers who the state would argue are not material to the case. They've interviewed other witnesses. They wouldn't even be called by the state to testify at trial. And the state objects to this because training records of specified officers aren't included within Rule 16. And they haven't proffered any reason as to why this would be needed for the preparation of their case. Again, these are investigators who have gone out and just interviewed some witnesses within the case.
That pretty significant. You see, I knew it. I knew that was the case where the prosecutor are no dummies. They're not giving her the records because they don't have to. I don't do whatever just because you ask. Long story short, the defense have a seat. She's sitting. Have several more seats, and watch yourself be schooled.
So we'd ask that you rule that this is outside Rule 16. And I would just remind the court that several hundred investigators have been involved in this case. Our concern with allowing training records for these few, which we can't understand why there's a substantial need for these particular ones, wouldn't open the door to us then having to go and obtain training records for these hundreds of investigative officers who've been involved, some of which are outside of our control. Moving on to...
Make a very good point. In law, precedence is a thing. Precedent is a thing. You see how many... Look, she just said she had over 30,000 pages, 30,000 images. Please, who has time to go through all that? But people do. And so you want to expedite as much as possible and streamline and make it as efficient as possible. If she has to prove records for these 3, then it opens the door for her to be like, well, how about the records of all the others? Very good point. Very good point. And I don't think, I'm not a lawyer, but I don't think the law requires any of that unless she, the defense, like specifically motions or says why these 3 specifically, and the prosecutor said, I didn't receive any of that. Have a seat, Miss Defense Lady. Have a seat. Enjoy the tax dollars, but have several more seats and giggle over there with your client. That really irritated me when they came in with the laughter because the prosecutor is not laughing. Please, everybody there is working very hard. How dare you laugh? Yes, I'm not that fun when I'm serious. No, because it's a serious matter. It's not a moment to have laughter and a kiki. It's serious.
The second motion to compel. As to item number 1, regarding cast information. Ms. Taylor has everything that we have. I've also, that includes reports from MPD officers. What she is seeking is a specific report from the FBI cast team, which I have indicated to her is in its final stages of review. And we are anticipating receiving sooner rather than later, and as soon as we do, we will turn that over.
Sooner than later.
Well, I don't have a date certain, but within the next few weeks.
I think Ms. Taylor wants a date.
I don't have
If
a
I'm
date.
not mistaken.
I have asked for a date, but that is not how the federal bureaucracy works.
That's, how about
There, Miss Taylor. Miss Taylor knows that. She's just playing fiddle. She understands how federal prosecution works. She knows exactly what she's asking. She's asking stuff that are deliberately difficult to provide because that's part of a strategy. They don't have a strategy over there. They don't know what the hell they're going to do because the DNA is the DNA. They have no idea how to go about this. But Miss Taylor baby is smart. And so she is going to wiggle herself into, I don't know, right? Good hair, though. Now, Kohlberger over there in the corner, plastered, stone-faced, unbothered. I wonder, is he taking a nap? He's not even taking a nap. But you know what? Let me tell you something. He's being stared at by the officer. I'd be like this too. I'd be so nervous. Oh, you know what? Look, if I knew I was going to have the death penalty, I'll play, like funny stares with the officer in front of me. Just make him uncomfortable. I'd be like this. I'd be like, oh, well, I'm going to die anyway. So, I think I'm dying anyway. I might as well have a good laugh, make you uncomfortable as hell. Because that bailiff is just staring. I will stare back. Wink, wink. Stare, stare. Flick. Oh my God, I'll stop. Anyway. Can you tell I'm a little bit bored with this already? A little bit bored. Quick reminder, listen, if you enjoyed this content, press like. Listen, I know this is a new thing. This is a new thing that I'm going to do all the time, so get used to it. I have to tell you to press the like button because a lot of people actually like it, but they forget to press it. Press the like button. It really helps my algorithm. Thank you. I mean, what else do we expect? Of course she's going to dispute everything the prosecution is going to bring out at her. Of course she has to. She has a client to do. She can't be like, all right, Mr. Prosecutor, you're right. Sorry, Kohlberger, goodbye. No, and also don't forget she has bills to pay. That tax dollar money is very good. And listen, people don't like to admit this. Listen. You give me the opportunity to get paid by tax dollars, I will take it. I tell you right now, I'm not even going to sugarcoat this. A government contract is one of the best contracts you could ever have. Honey, they pay on time, and the money is always flowing. What? It's the best. Matter of fact, I'm trying right now to get a government contract. I'm trying so hard to get a government contract. I will even reduce my pricing for the government contract if it could just secure it for a couple of years. What? It's so difficult. They're like, who is this? What is this? I have insurance. I'm out there. Open the door. Just let me in. Do you have a wellness program? You don't? They don't, because governments here take care of their people. Okay, can you make one? Yeah, they don't see any value into fitness in the government space. They don't see any value into tax dollars funding your entertainment because they see fitness as entertainment. Listen, fitness is not entertainment. Fitness is preventative medicine. Government, no, I'm trying to get in the government contract. It's good. So, blonde lady lawyer, I understand why you want to prolong this thing because that tax dollar paycheck for Kohlberger, it's heavy and it's good. This story, like the fight has begun. The Kohlberger fight from the prosecution and defense has started. Ding, 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 ding. No, Kohlberger is extremely composed. Honey, this guy believes he's innocent. Maybe he is, but for the life of me, you know what? Maybe someone who believes he's innocent. Can you explain to me what his DNA is doing on the knife sheath? And listen, statistical match, it's not insignificant. That means it's a match. It's so much of a match that they don't want to be sued and say it's him. So to prevent legal repercussion, they call it a statistical match. Please. It's the same thing for like, you are the father. You are the father. They say percentage-wise, honey, you're the father, 98%. You're the father. Oh, but no. It's just a mumbo jumbo semantics of words. You understand? Behind, if you read between the lines, no, it's him. It's him. So explain to me what that DNA stuff is doing there, right? There's no serendipitous feather that flows and blows and my skin cells flies all the way to Idaho. Oh, Alistair was there. That could happen. Statistically speaking, it's not going to happen, but it could. That's what statistical match means. And the cell tower, excuse me, what are you doing around the house of the murdered victim 2 times? Explain that to me. You having a good old jog? Explain that to me, you know? So it's one of those things, and let me tell you something, even if you get scot-free, listen, I got news. Right. Listen, I got news for you. If he's found not guilty, and he's like, I'm not guilty, I'm going to go and apply for a job, he's not going to get hired. He's not going to get hired. Because you might say to yourself, well, you know, I'm found innocent. Yeah, but as the person doing the hiring, I will find another excuse not to hire you. Listen, I've done it. I've done it. There are laws in this country, but it doesn't. The laws are there. Sorry for the dog barking. But if you don't want someone around you, you find a way to make sure you don't get hired. That's what lawyers are for. This guy would never work again. Just like Buster from Murdoch, he'll never work again. You remember Trevor Martin, the murder of Trevor Martin? He was found not guilty. Where is he now? Please, depressed as a hell. He's not working. He'll never work ever again. Like, you don't underestimate the power of public opinion. If I see Koberger on the street, you best believe I'm crossing the other way. If I see Koberger on the airplane, I'm not flying the airplane. I'm complaining as hell as all that. You know, do you understand what I'm trying to say? No, there's ways to go around the legal mumbo jumbo of the situation over here, which is like the legal framework. So as much as I'm nervous that he maybe might get scot-free, I am fully confident that if he escapes, he could never explain to the public the DNA match. Look at O.J. Simpson. No, some people like him. We all know he did it, allegedly. But we all know OJ is a murderer, allegedly. So you go hang out with the murderer. Matter of fact, go sleep over at the murderer's house. You're the one who's stupid, not me. Anyway, that's all for the final thought. My dog is barking like crazy. Shut up! Oh, it worked. All right. Let's go to my Let's Talk. It worked. For those of you new here, Let's Talk is where I just take off my jacket, get comfortable and talk to you about anything and everything. Look, I hope... Oh, by the way, yes, I have to do another spiel. Please press like if you got this far and subscribe if you haven't done so. Hey. Listen, what an interesting week this was. So, you know, we went to Seattle for vacation and they lost our luggage. That's why I haven't shaved, because my good razor, the expensive one, is in that suitcase, and United lost it. And I'm not shaving. I'm waiting for my freaking suitcase. Ooh, Chris was so mad. I've never seen him that angry. I said, Christopher, it's just a suitcase. We can buy a new suitcase and a new razor. Oh, Christopher was so mad. He was like, no, it's a principle of it. It's a principle of it. It's a principle of it. Not only do you delay our flight, cancel it, knowing it was going to be canceled anyway, but we're sitting here, wondering what's going to happen to us. Then you put us in the shit in a crappy hotel, and then you lose my suitcase, and then not a thank you, I can't get in touch with you. You're not even... No, it's a principle of it. Chris was really mad. Usually I'm the one who acts up. I had to be the calming force of reason. I was, oh wow, look at that. I have to pee. What? Too much information? No, I have to pee. I tell you, but I can't get up yet. No, I'm on a tight schedule. If I go and pee, I might change my mind. I might be distracted, but I really do have to pee. Anyway, so Friday we're going to have the live, first live of July. It's just pre-recorded content, so I have no idea what day this is going to come out. It's going to come out when it's going to come out. That's what it is, right? New person, new month, new system, new process. Everything is brand new behind the scene. Maybe I'll tell you one of the other videos. I'll tell you some of the stuff, but no, I had to go to the drawing board and rethink a few things. Yeah, I got in so much trouble in the month of June with people that pay my bills, okay? You don't understand. When you get scolded about numbers, stuff you can't even lie. It's like grown-ups scolded. They won't lie at you, but they'll tell you you suck. They'll be like, unacceptable. This is use words like this. Mediocre. Oof. Unacceptable. Oof. This is not what you this was not part of your proposal. This was not part of the contract. Oh my god, these words just makes me what? You want to be scared? You talk to those CFOs who are angry at you. They won't even shout and yell. And the way they look at you when they say those stuff. Oh my god. My god. And you know, for Seattle, you know, it was Christopher's business conference. And so they sponsor most of the trip. And so I just tagged along as the spouse with the kid. That was a vacation. Please, they paid for it. Why would I not? Sorry, decline. It's a phone call. They pay for it. And I was like, why would I not take advantage of that? Yes. And he's a healthcare actuary, and so they rent out pretty much the lobby of the hotel and the whole floor of the hotel, please. And they house everybody. Oh, please, it's money. We all know behind the scenes, the reason why they do that is to, let's say if they have a good year, a good profit year, they spend a huge lump sum of money under the pretext of a work conference so they can tax deduct. Please, they have accountants who figure out how much they need to spend to equate to how much. Please, it's all part of the game of legally not paying taxes. We all know the game, you know, but enjoy for the ride. It's free food, free hotel, free everything. And but they were there, and I saw big shots in the healthcare industry. And they brought their spouse and kids. Like I wasn't the only one. But honey, the way they talk about you behind your back, sometimes I'm like, oh, I don't want to work for here. They talk so much shit around each other's back. Like, I was like, wow, are you HR? Oh, and you are like what? Diversity person? Wow, you guys are talking a lot of shit. I was taking notes. Please, I'm not going to open my mouth and then have my husband lose his job. No. But I was looking and I was like, wow, you all very shitty. But all right, since we're laughing about it, ha. The booze, the drinks were free, and I had the harness. Put the harness, and I put Olympia in the harness, and I was sipping my booze with the baby up here. Olympia was so good. Didn't you know that she wasn't crying, she wasn't fussy, and you know they serve you food, darling, and like take a little bit. She was eating right there, and then when she wants more, she goes like this, and she wants more. It's so funny. Sometimes I joke with her, I tease her, I give her a little bit, and I wait, and we go, we do it together. It's so funny. What? This dog is barking like crazy. I don't understand. Who's there? Am I being murdered today? Maybe. No, I'm not. Please. I have security everywhere. I would see it before it comes. And I have escape. I think I told you, right? I have a panic room. Now, you're have to work for this meal. Click. Help. It's so great. Anyway. What was I talking about? Yeah, the conference. Yeah, Seattle. So those CEOs, now it's my job, they were very upset and they were talking to me. They were making fun of me. They were talking to me with some greasy words. I knew I could read between the lines, but that's what I'm a grown up. That's what it's about. I just don't go in there and make a big fuss about it because my numbers were quite terrible and I couldn't explain it. So I was like, okay, I just took it. One more story. Oh, one more story. And then I have to go. No, I'll save it for next time. Please, honey, I need content. See you next time. Thank you so much. I'll save this extra story for the next recording I'm going to do. Ooh, it is juicy. I can't believe I did that. You know what? Sometimes I amaze myself in how ridiculous I am, but this is what life is about. Life is about having fun. You have one life. You have one life. What are you doing living it for somebody else's standards? Live your life. Don't hurt anybody, but live your life. Bye. Love you for watching.